Ladies and gentlemen, thanks for joining the last session of the KICIF International Forum. It is my great pleasure of participating in this forum as a moderator. I'm Seonghe, Deputy Director of the International Cooperation Division at Korean Institute of Criminology. First of all, I'd like to extend my sincere welcome to all the speakers, discussants, and audience. This session will last for about 1.5 hours with the theme of cybersex crime. In particular, the session will address online sexual abuse, online sexual offender typology, and victim support. We will have 3 presentations and then panel discussion in which one discussant is designated for each presentation. This session will be live streamed via YouTube, and Korean English interpretations are provided. I have no doubt that this session will help you better understand cybersex crime, and you will enjoy it. Before we start, let me remind speakers and discussants, because our schedule is a little bit behind, so please have each presentation within 20 minutes and each discussion within 10 minutes. Now I'd like to invite the first speaker, Dr. Adam Basler, Professor and Chair of the Department of Criminal Justice and Criminology at Georgia Southern University. Dr. Basler is a board member of the American Society of Criminology Division of Cybercrime, the International Interdisciplinary Research Consortium on Cybercrime, and the European Society of Criminologists Working Group on Cybercrime. His research focuses on the applicability of criminological theories to cybercrime offending and victimization, and the law enforcement response to cybercrime. His topic is image-based sexual abuse, revising legislation to match the behavior and not the intent. Let's welcome Dr. Basler. Dr. Basler, please.
Hello, everyone. My name is Adam Basler, Professor and Chair of the Department of Criminal Justice and Criminology at Georgia Southern University. We have campuses in 3 locations, in Savannah, Statesboro, and Hinesville in Georgia, which is the United States of America. And I was asked to give a presentation on cyber harassment, but within a cybersex context. And when I was thinking about ideas on what I really wanted to present, I thought the most important issue to discuss is how we can improve our legislation around image-based sexual abuse. When we start talking about image-based sexual abuse, it's important to think about all the different technologies that have existed and continue to be created over the last a couple of decades, and will continue. We always talk about how these digital technologies are always used for positive purposes, and we start talking about how some of them are used for criminal offending. But I don't think we really talk enough about how almost every digital technology you can think of in the past, right now, or every technology that will be created in the future all has an ability to somehow inflict gendered violence against women and children. And it's something that, although we talk about how technology is related to cybercrime, we do not give enough focus on the impact that it has regarding women and children. So a pretty straightforward definition of image-based sexual abuse is the threat or actual non-consensual sharing, posting, or dissemination of nude or sexual images. Quite often, in the vernacular, people refer to this as revenge pornography. And a lot of legislation might refer to it as revenge pornography. But as we're going to see in the presentation today, we really shouldn't be referring to it as pornography because it has nothing to do with the idea of it all. It's simply just sexual abuse against women and children. And so a better way to think about image-based sexual abuse is the idea that it is an umbrella term that encapsulates a lot of different types of behavior. Paul et al. Point out that there's 3 different types of behaviors that fall underneath this larger category of image-based sexual abuse, with the first one being the non-consensual taking or creation of nude or sexual images. These are instances where the victim did not even know that their photos or images of themselves being nude were being taken. This could occur through hacking, or quite often also could happen through pictures of film being taken of individuals in public restrooms in similar places. The second type of behavior is what most people would refer more commonly as revenge pornography, which is the non-consensual sharing or distribution of nude or sexual images. And finally, we also have to realize that some of image-based sexual abuse is not just the actual sharing, but it's the threats of it. It's the blackmail of it, trying to get someone to do something that the offender wants by threatening to share these type of sexual images. So throughout this presentation, we should keep this much broader definition of what we mean by image-based sexual abuse. When we talk about the scope of the problem, it's quite challenging because our statistics vary so much by how we define it, the methods that scholars use, the different countries that a lot of these studies occur in, and also the sampling about whether we're talking about grade school, high school, college, or young adult samples. But when we look specifically at non-consensual transmitting victimization, what a lot of people would call revenge pornography, we see that for minors that it seems to range anywhere from 10 to 20% of minors have been victimized, where someone that they trusted with a nude photo of themselves sent it to someone else or showed that picture to someone else without their permission. For adults, it appears that the victimization prevalence is actually lower, somewhere between 1 to 12% possibly. However, when we start talking about perpetration, we see that there's a much higher percentage. That when we quite often talk about the dark figure of crime, these are usually crimes unknown to the police, and we start talking to victims, we start finding out that there's a lot more crime out there. However, when we talk about cybercrime, including image-based sexual abuse, we find out that there's a lot of crime that victims don't know about. So when we talk to offenders, it appears that 12 to 30% of minor and young adult samples have shown or transmitted a sexual image to someone else without the consent of the person who originally provided that picture. That's a pretty shocking statistic. When we look at the impact on victims, we see that the effects can range from emotional to social and economic. And of course, it can lead to some issues such as anxiety or lack of trust and loss of confidence in oneself. It can really lead to fear, depression, and suicidal ideation. In fact, according to a lot of organizations, it seems that almost a majority of victims will have experienced some type of severe mental health as a result of being a victim of image-based sexual abuse. The social effects can also be including exclusion and alienation, not wanting to hang out with your friends, or actually not wanting to go online, trying to stay away from the abuse. Economic effects can, of course, include court costs, lost jobs, and the amount of bills that can come with all the mental health impact. These effects are both short-term and long-term, with the effects quite often not only ranging in months, but also in the years. When we talk about what we should do about image-based sexual abuse, we quite often only focus on it from a criminological perspective, a very narrow view, but we really need to examine from a much broader perspective. And most scholars out there who are studying who are studying image-based sexual abuse really argue we should study from a feminist approach. And we do that, we can really see the amount of inequality out there and how that leads to patriarchal society. That we really need to look at the offending of image-based sexual abuse, the victimization of it, but also the legal response to it, which is what we're talking about today. And when we start looking at the legal response to it, we start asking questions not about the actions that victims take, but really the actions of the offenders and why society accepts and approves it, such as why is there such a demand for pornography in general? Why is there such a demand for amateur pornography, for different types of gonzo pornography? Why do we put the blame on the victim rather than the offender? Why don't we actually try to do more about this? And quite often when we look at why we don't do more about this, it tells us a lot about our surroundings and the society we live in. So we need to start taking this much more seriously in a feminist perspective as an important way to deal with this, because we won't be able to legislate our way out of it. We really have to do more about gender inequality in general in our society and try to erode the culture of humiliation that exists in general, but especially attacks women and children. When we look at U.S. legislation, we do see that most states have passed what they might call revenge pornography legislation. Only 4 states have not in the U.S: Wyoming, Mississippi, South Carolina, and Massachusetts. However, most states really only consider it to be a misdemeanor. Some states do consider it a felony, although quite often they have a lot of restrictions on it. A lot of states simply try to deal with image-based sexual abuse by its current child pornography or blackmail statutes. When we look at what really needs to occur in the U.S. and very possibly around the world, but this presentation is really only focused on the U.S., we need to move away from certain terms. Words matter. We have to move away from phrases such as revenge pornography and move to phrases such as image-based sexual abuse. As pointed out earlier, this has nothing to do with pornography. It is a way to humiliate and try to control women and children through sexuality and to try to keep them in a certain position in patriarchal societies. In addition, we need to try to have our legislation not refer to the intent of the actor. In some cases, it might be about revenge or harassment or humiliation, but there's many other reasons why image-based sexual abuse continues to occur. Therefore, the focus really needs to be on the act itself, the fact that it's the non-consensual transmission or showing of these images. Then in the end, it doesn't matter why the person did it. It makes us focus on the offender in the act rather than the sexuality of it. And also it makes sure that we do not have to try to make the victim defend their actions. So instead of asking the victim why they took the picture, why did they share it with someone else, and it also asks whether there was consent to share. Instead, it makes us focus on the offender. Why do you have the photo? Were you allowed to have this photo? Why did you choose to share it? Did you explicitly have consent to show this picture to others? And can you prove it? And many examples of good legislation in the U.S. can be found on the website of the Cyber Civil Rights Initiative, which is a nonprofit organization. And when we started looking at some of their models, they show some examples at both the federal and also the state level. So when we look at the federal level, for one of their examples, in case if the U.S. wants to improve their statutes or if another nation wants to try to follow the steps of the U.S. a little bit, we see the first half of this model really kind of fits the Computer Fraud and Abuse Act in the U.S. about how the internet and electronic devices and wires should not be used for illegal purposes if it's going to cross state, federal, or international boundaries. But when we look at the second half of the statute, we see some important aspects. First, it's that whether a person can be identifiable and whether they can be connected with any type of sexually explicit conduct. Then it also includes whether any type of naked genitals or nipples are exposed. Those two things are important to distinguish because quite often a lot of revenge pornography statutes only focus on whether the person is identifiable, but also whether any part of the image shows them nude. And if it doesn't show any part of themselves nude, it's very possible the statute does not apply. So you could have a fully clothed person who's identifiable who's participating in oral sex, and revenge pornography statutes would not cover that. Or if there's something else, such as if the victim is shown being is simply having been sex or rape, but at no part, if their sexual organs not being shown, the revenge pornography statute might not actually cover. So it's important that these statutes also include when the person is clothed, but it's clear that the person is engaging in any type of sexual activity. And then it's also, as we point out, there's no intent anywhere in the statute, and whether the offender had knowledge of or reckless disregard for the fact that the depicted person did not consent to the distribution. When we look at examples for state law, it's also quite similar as well. For an example of if any state wants to improve, there's no discussion of intent in these statutes. And once again, it covers whether the person is participating in any type of sexual act or whether there is any type of nudity shown in there. And when we look at these statutes, they provide very good definitions. So we can see how inclusive the words disclose mean, or image, or what's all involved in intimate parts or sexual acts. The Cyber Civil Rights Organization, as I mentioned before, which is a nonprofit organization in the U.S. that was founded by a victim of revenge pornography, and their website has been quite instrumental in the passing and endorsement of some of these improvements of these statutes. They point out that the Illinois model, or the laws that Illinois has, is a pretty good statute in order for other states to improve what they're currently doing. They provide 7 reasons. Because of time, I'll quickly go over some of these. But when we look at the Illinois statute, they do not talk about motive. Selfies can be included because it does not matter where the picture came from. We should not be blaming victims. In fact, a majority of non-consensual pornography starts off as selfies. So the real issue, once again, is the offender sharing this information, sharing these images without consent. The Illinois model has strong punishments associated with it. It is not only just focused on nudity, but once again, sexual acts that it's clear the person is participating in and the person is identifiable. It's also very important because it also focused on downstream distributors. Some statutes only focus on the very first person who shares the image without consent. But it's important that statutes focus on whether a reasonable person would know that they should be sharing and further showing these pictures to other individuals. So downstream distributions of these images would be illegal as well. It honors the First Amendment, meaning that it allows for legal pornography. It also allows for people to report these images to the police. It allows law enforcement to share these photos with other law enforcement agencies in order to do investigations. And also specifically discusses doxing, where quite often we see over half of these types of illegal images provide images and information on the victim. So it makes it illegal for individuals to contact these individuals, to contact the victims and to harass them. We should point out that this is also very relevant for South Korea as well. Over the last several years, there's been quite a few international cases of revenge pornography, or also MOCA, the illegal filming of people with hidden cameras. And although there has been some statutes passed over the last couple of years where distribution of revenge pornography is up to 3 years of prison, and if it's actually filmed illegal, it might be up to 10 years, we see that the fines associated with these offenses are quite low. That in U.S. dollars is only $4,500 or possibly $9,000 even for a felony. And then we talk about MOCA offenses. Some estimates show that maybe only 2% of them are actually in the prison sentences. And so this is just not a U.S. issue of not taking this issue seriously enough, but it seems like many countries could improve their enforcement of this. So how do we move forward? In the last couple of minutes I have, how do we move forward with this? It's important not only to improve our legislation like I've been talking about, we also need to desperately improve our training and funding for law enforcement to deal with these. There's simply not enough focus on it for law enforcement and prosecutors to examine these issues more. And part of this training actually might focus on the impact of the victims. If law enforcement understands how significant that these crimes are to victims, they actually might want to get involved more. Law enforcement needs to learn more about the referrals that they can give to the victims, such as victim advocacy referrals. The officer and the victims also have to know more about what options they have. So if a victim asks a police officer, what can I do? A police officer has to be able to know what they can tell the victim, or at least refer them to the correct agency. As I pointed out, if we really tackle this from a feminist perspective, we realize that we can't deal with this simply through legislation, but we really have to do more about gender inequality and try to deal with that. And that actually have the largest impact in the short and long term, and not just trying to change some wording with legislation. And finally, last slide, I just want to point out that we don't need to reinvent the wheel. As I've been talking about, there's many organizations out there, but one good example of a nonprofit organization that's making a big difference is the Cyber Civil Rights Initiative. And they have many good statutes that I've been talking about. Any person who's interested in this can actually read reports. They can look at the statutes for every state in the US. They can look at those model statutes. And they can also find out how they can become involved if they want to try to make a difference with this. So once again, thank you for inviting me to give a presentation on this really important issue. And I'll reserve questions. You can either email me or when the presentation goes live, I'll also be more than happy to talk about this and answer any questions. Thank you for your time.
Thank you very much, Dr. Bosler, for your presentations. And we are going to have discussion panel later when you finish all the presentations. We are going to have the second speaker, Dr. Ashley Ball, Senior Research Associate in West Edge Health and Justice Program. Dr. Ball has conducted research and evaluation on diverse topics, including training for law enforcement, tasked with investigating technology-facilitated crimes against children, and innovations for intimate partner violence offender, among others. Her work has been published in prominent academic journals, including Psychological Assessment, American Journal of Preventive Medicine, and Violence and Victims. Her today's topic is examining online sexual exploitation of children offender typologies. Please join us in welcoming Dr. Ball. Dr. Ball, please.
Hello, everyone. My name is Ashley Bull, and I'm a Senior Research Associate in WestEd's Justice and Prevention Research Center. And I'm happy to be here today to discuss online sexual exploitation of children offender types, including where they converge and how they can be used. Before I start, though, I do want to take a moment to acknowledge the team that supported the development of this presentation. I truly appreciate all of your work to make this possible. So thanks to everyone on this list. So with that, I'll go ahead and give you a roadmap of what I'm going to talk about today. I'm going to start by giving a brief introduction to what I mean by technology-facilitated sexual exploitation of children. I'll then give an overview of available typologies to help build understanding of the characteristics of offenders of these types of crimes. After this overview, I'll describe where these typologies converge and how they differ, and I'll conclude by highlighting why these typologies are useful to law enforcement, as well as their limitations. So I'd like to start by grounding everyone in what I mean by technology-facilitated exploitation of children. Defining terms in this area can be difficult. Individuals from research, law enforcement, and legal backgrounds utilize varied terms, and even within these groups, there's a large degree of variation in how terms are used and defined. This variation creates challenges in conducting research on these crimes in a systematic way. For example, it can make it harder to document the frequency of these crimes and compare crimes across countries or jurisdictions when definitions vary. With this caveat in mind, I'll share how we conceptualize technology-facilitated sexual exploitation of children to guide our examination of offender typology. Our working definition is inclusive of online sexual solicitation of children, which includes asking children to engage in sexual activities or talk. It includes technology-facilitated sex trafficking, such as using the internet to assist with the recruitment or soliciting of a child for a commercial sex act. And it includes the production and distribution of child exploitative materials. This definition may be helpful to keep in mind as we think about the volume of these crimes and the types of offenders who commit these crimes. We know that technology-facilitated sexual exploitation of children is a large and a global issue. For example, since 1998, when the cyber tip line for the National Center for Missing and Exploited Children, or NCMEC, was created in the United States, they have received more than 74 million reports of potential child exploitation, including abusive images of children, online enticement, child sex trafficking, and child sexual molestation. In 2019 alone, the cyber tip line received more than 16.9 million reports. The constantly evolving and anonymous nature of the internet allows offenders to engage in these crimes from locations all over the world, creating challenges for law enforcement as they try to navigate how to identify victims and apprehend offenders in this global and cross-jurisdictional context. Given the pervasive nature of this issue, researchers have attempted to develop typologies to better understand offender strategies and their motivations. Although the details of these typologies vary, they share the ultimate goal of better understanding offender strategies and motivations in order to ultimately inform decisions regarding investigation, sentencing, treatment, and supervision. So they do have the potential to be quite useful. When we go to the literature to determine what typologies should be considered to better understand offender motivations and strategies, we see that there have been numerous typologies offered to better understand these offenders, most of which emerging over the last 2 decades. So I'm going to take some time to walk you through each of these typologies briefly. The first typology was offered by Hartman and colleagues, and it was published in 1984. And this typology was not focused on online offenders. Instead, it was focused on those who collect sexually abusive images broadly, so pre-widespread use of the internet. Although it's not specific to online offenders, you will see that the 4 types identified by Hartman and colleagues share many similarities with the technology-specific typologies that appear to have set the foundation for these more specific typologies that emerge later. This typology includes 4 types that are differentiated by whether the offender collects sexually abusive images in secret without contact, collects images in conjunction with contact, shares images with others, or seeks financial gains from their collecting behaviors. The next typology was published in 2004 by Crone. This typology differentiates each type by examining the extent to which the offender networks with other offenders, the level of security utilized to prevent detection, and whether the abuse is indirect or direct. As you can see from this typology, it resulted in a large number of offender types that differ across these 3 dimensions. And the result of this typology is that it functions kind of like a trajectory of offending behaviors from least to most serious, with those who may accidentally view child exploitative materials, perhaps by responding to spam or accidentally clicking something on a website, all the way to those who have physically abused children, as well as those who produce and distribute materials of them or others abusing children. So it really shows quite the trajectory. Sullivan and Beach also published a typology in 2004 that was focused more specifically on offenders who collect abusive images rather than the entire spectrum of abusive behaviors. This typology specified 3 types that varied based on whether or not there was contact and their intent behind collecting, with some offenders collecting out of curiosity without the desire to have contact with children, and others collecting to feed their progressing interest in children and potentially having contact. Alexi and colleagues suggested yet another typology just a year later. This typology was developed using data from print and media coverage to examine characteristics of offenders. This analysis resulted in 3 types that vary based on whether offenders traffic or collect child exploitative materials online, engage in discussion with children and attempt to meet them in person, or engage in both those behaviors. In 2011, Briggs and colleagues examined internet chat room records from offender cases and developed a typology based on those records. This typology is somewhat different than some of the others that are out there because it doesn't focus on offenders broadly, but instead is focused on the subset of offenders who engage in chats with minors. So it's less about those that collect and distribute materials and more about that personal interaction with the children over chat. Based on their analysis, they specified 2 offender types: those whose goal is to make contact with children, and those whose goal is to engage in explicit discussion online without ever meeting in person. Webster and colleagues also took a different approach than some other scholars in developing a typology that they introduced in 2012. Rather than looking at behavior, these researchers conducted interviews with offenders to better understand their motivations and classify their grooming behaviors. In their framework, the 3 types are differentiated based on previous sexual offending, whether or not they concealed their identity, and the extent to which they had exploitative materials of children. It also utilized information about their level of networking with other offenders to differentiate the types. The next typology that emerged was developed by Tenner and colleagues in 2015. The authors utilized law enforcement reports to develop offender types. This typology includes 4 types that differ based on their patterns of online communication, such as whether they meet the victims online or know the victims in person first, and then communication progresses to online. They also included the extent to which they conceal their identity and the relationship dynamics of the victim with the victim, such as the speed of the relationship and whether it's reciprocal. The level of sex crime expertise was also considered as a factor to differentiate these types. In 2016, Clevenger and colleagues published a study examining characteristics of offenders, which resulted in their description of 3 specific types that emerged in their data. From this research, they determined that characteristics of offenders differed among those who exclusively possessed child exploitative materials, those who attempted or committed physical contact, and those who produced or distributed child exploitative materials. The final typology in this review was offered by DeHart and colleagues in 2017. To develop their typology, the researchers examined evidence from technology-facilitated crimes against children cases and identified 4 offender types. These offenders varied based on whether they attempted or committed physical contact and whether they paid for exploitive materials or contact. So as you can see, there are a large number of typologies available, with each using different language, different criteria, and focusing on different parts of the offender population. Given this, we thought it would be helpful to unpack how these typologies converge and where they differ. In looking at the typologies, we examined the criteria used to differentiate offenders, and this led us to 8 different dimensions that we saw used within at least 2 typologies, as well as some other factors that were used in kind of one typology but not repeated elsewhere that aren't included here. So as you can see, whether or not offenders attempted or engaged in physical contact with victims was used across all typologies. This appears to be a very meaningful differentiator regarding how an offender behaves and what their kind of trajectory of offense looks like, regardless of how the typology was constructed and what offender population it was focused on. Whether or not offenders collect child exploitative materials was another common dimension within these typologies, and it was observed in 7 out of the 9. And the 2 typologies that don't differentiate based on whether the offender collects explicit materials were the typologies that were focused on internet chat records and offender motivations. So I think it seems that the lack of inclusion there is really specific to the population or kind of the orientation of the typology. Whether or not exploitive materials were shared with others and the level of networking with other offenders was included as a dimension in 4 of the 9 typologies. The frameworks that didn't utilize this dimension were those I just described, as well as those that focused more on using the internet to engage with children, for example, through chat, rather than to network with other offenders. Intent was also a dimension in 4 of the typologies, And interestingly, this dimension was utilized in nearly all of the typologies that did not include the sharing dimension. The ones that included the sharing dimension appeared to be more focused on behaviors, while the ones that included the intent dimension appeared to be more focused on motivations behind the behaviors. So that kind of helps differentiate why those factors were present in some and not so much in others. 3 typologies considered the offender's technical sophistication or their ability to hide in cyberspace or conceal their identity as a dimension to differentiate types. And this dimension actually, interestingly, went across those that could be seen as more focused on behavior as well as those more focused on motivation or intent. Just 2 typologies included a financial aspect, including whether offenders sell exploitative materials for profit or whether they pay to receive exploitative materials or contact. And finally, two typologies explicitly included sex crime history as a factor for differentiating offenders. And these same 2 typologies also included a dimension about offender dynamics with their victim. This consolidation helps us understand what factors might be the most useful to differentiate offenders. Across all typologies, it appears that physical contact, whether images are collected or shared, offender intent, and ability to conceal are probably the most useful or are going to be viewed across multiple sources of literature as important compared to some of the others that may be more specific toward a certain subgroup. So although these typologies may be helpful to consider, I do want to note that there are several limitations when we want to think about offender typologies and how to use them. First, there has been limited synthesis across typologies, which can make it difficult to know which to use in practice when different typologies offer different advice on how to think about offender groups. Second, the extent to which and type of data used to develop each typology varied widely, as did the samples. This creates a situation where a one-to-one comparison of typologies may be inappropriate without considering the context in which it was created. So really understanding, was this typology focused on internet chat versus was this focused on arrest records, and what does that mean for interpreting it? Finally, and in my perspective, most significantly, there's a lack of research testing the extent to which these typologies are actually useful. Further research in this area would help determine which typologies are most accurate and the extent to which typologies should be relied on in the field. Despite these limitations, we know that the number of cases law enforcement is tasked with often far exceeds the number they can actively investigate at any given time. To ensure resources are directed to stop the most dangerous offenders and save children in most immediate harm, the prioritization of cases becomes important. We know that cases should be prioritized when they involve production of child exploitative materials, luring of minors to meet in person, and cases with offenders with a known history of committing these types of crimes. Thus, training should emphasize strategies to investigate the most dangerous offenders, which potentially could be identified by having a solid grasp of available typologies and the characteristics to look for within these typologies. So if you remember back to earlier in this presentation, I noted that typologies can be helpful to understand offender strategies and motivations, as well as to inform investigations, sentencing, treatment, and supervision. With this in mind, the practical application of typologies might help make decisions regarding which offenders are most likely to do the most immediate harm, which offenders are likely to engage in the most harmful offenses, which investigative strategies might be most appropriate for a given offender or a given type of crime, when to push for harsher sentences, and the appropriate approach to supervision and post-release requirements. All of these decisions can be incredibly difficult to make, but are extremely important to effectively protect children. Typologies are one piece of information that may be useful in making these hard calls. So with that, I will share with you the references that were discussed in this presentation, as well as my contact information in case you have any questions after today's presentation. Thank you so much for having me.
Dr. Bauer, I greatly appreciate your presentations. And I have a quick notice for speakers. During the session, we receive questions in the chatting window. Due to the time limit, we cannot address the questions, but it will be grateful if speakers can answer the questions. I think we have questions already, maybe for Dr. Butler, so why don't you check the chatting window? Okay, let's have the last speaker, Ms. Seonghe Bach, Manager of Advocacy Center for Online Sexual Abuse Victims at the Women's Human Rights Institute of Korea. Before joining the institute, she served as CEO of a documentary of a women's video production company. Also, she got involved in many projects such as Seoul International Women's Film Festival and Women's History Exhibition Center at the Ministry of Gender Equality and Family. Her topic is Understanding Digital Sexual Violence and Victim Support. Please welcome Manager Seonghe Bach. Seonghe Bach, please.
네, 안녕하세요.
Hello. My name is Park Seonghe. I'm with the Advocacy Center for Online Sexual Abuse Victims at the Women's Human Rights Institute of Korea. I would like to briefly tell you a little bit about the work that we do at our Advocacy Center. We are seeing digital sexual violence on the rise, and that is why in 2016 there was a comprehensive act that was passed in Korea. In 2017, the act was passed, and in 2018, the next year, our center was established. And as you can see, we offer counseling, support, and the removal of images, leading the support, and also we also help the victims work together with other support organizations like the Sunflower Center and various other victims advocacy groups, also advocacy groups for children, for young minor victims as well. So we also liaison with other support organizations. Let me tell you a little bit about our victim support system. We have an online bulletin board. We also have a hotline that's open 24 hours a day. So we can receive calls and reports 24 hours a day, as I mentioned, because we have this open line and a hotline, and we can immediately provide victim advocacy through counseling support and to help them remove these images from the internet. For those victims whose images have been found to be distributed, or even if not, we continue to try to monitor the situation to see if the images have indeed been distributed. So we try to help the victims alleviate their concerns and their anxiety. And if the images have been found to be distributed, then we try to remove those images with the help of various other interested parties, such as the police agency and the Korea Communication Standards Commission. So we work together with them in coordination through also with investigative activities. Let me just briefly share with you some statistics. This is up until last year, so this is the most current statistics that we have. There's illegal photography, distribution, threat, or blackmail, and anxiety, etc. And I'm going to tell you a little bit more about this later on, but there's also photo augmentation, which is photoshopping, and cyberbullying or harassment. So we try to see this from the point of view of victims. Earlier, Professor Adam Bosler said that it's important for us to take a feminist perspective. We also think that it's very important and also try to see this from the point of view of media literacy. Our employees continue to try to get advocacy training and education so that we can help victims better. Obviously, 60% of the victims suffer distribution or sharing of these pictures and non-consensual filming. We ask the hosts and web managers of different P2P sites and porn sites to take down the images. Let me share with you some of the statistics that we have for the first half of this year. There have been some big issues as of late in Korea, the Telegram incidents, and in April, the perpetrators were arrested. Since April, we've seen a huge increase in the number of reports, victims coming forward to us. And so the government has actually even passed an extra budget. And beginning the end of August to September, and even now, we've been providing even more advocacy to victims. We've brought in an additional 50 employees. Currently, we have already removed about 170,000 images. As you can see here, this is for the first half of this year. We were able to help about 2,100 or so victims. This is almost equal to the entire number of victims of last year. So just first half of this year, we've seen a number of victims that is commensurable to the number of victims for the entire year of 2019. We've been able to see the outrage in Korea after the Telegram incidents. We've seen a lot of calls coming in. All of this really began with the Telegram incidents, but this has, I think, raised more awareness about the issue of cyber online image-based sexual violence. We've also seen a lot of calls from minors as well and young victims. Next, I'd like to talk about the different kinds of types of digital sexual violence and the different support services that we offer to them depending on the category of the abuse. This is the category that we use within our center, within our advocacy center. So you might think that this is a lot of different categories, but in fact, these come with additional subcategories. First is obviously the most well-known, which is the illegal or non-consensual filming or taking or creation of these explicit images. Maybe mostly in cases of public places like public bathrooms and etc. Many of these cases, the victims are very motivated to voluntarily report the crime, and they really help out with the authorities to try to take down the perpetrator. And then there is also the non-consensual distribution of these images. In many cases, we hear from victims who've already seen the distribution of their images online. In some cases, the videos or the images have been altered. They've been easily edited. In fact, people can edit it very easily with their smartphones now. And in some cases, the perpetrator would upload these in a series, in a story. In many of the cases, the victims become cognizant of this after the fact. And also, they hear about it through a third party. So they would call us saying that I heard from a friend of a friend that they saw my image somewhere. What should I do? When that happens, we try to move really quickly to try to monitor the situation, see where the images have been distributed so that we can take them down and remove them from the internet. In some cases, if the victim is a minor, it's difficult really to work together. We have to prove that this was non-consensual, which can be difficult, especially if it's a minor. And it's difficult for anyone really to give consent for the distribution of their sexually explicit images or videos. So we have to always make very clear that this was largely non-consensual. I have to say that Dr. Bosler's presentation was really memorable for me because we should not focus on the intent, but the fact that this was non-consensual, really, it should be the most important focus. We have to really look at this from the victim point of view. And that's how we have to address the situation. And I hope that's how we can have that here in Korea as well when we revise the relevant laws. There's also a lot of blackmail involved for distribution. Even if there was no distribution, the perpetrator would threaten to distribute this to other people. This could lead to a lot of anxiety for the victim, and there could be consistent blackmail, consistent threatening. And so it is very important to try to provide counseling to the victim. But because the victim is in so much pain and suffering, the victim is later, she tries to leave the chat room, or she just tries to remove all the images from her phone because it brings her so much suffering. But when that happens, when she leaves the chat room, then we lose access to a lot of the evidence. So we try to provide psychological supports and counseling while having access to that evidence so that can help the authorities in their investigation. all victims are understandably afraid that there's going to be redistribution because, unfortunately, we also recognize the fact that once it is online, there can never be a perfect takedown or perfect removal of all of these images because these are files and they can be readily distributed and shared by many people and stored and saved in their other devices. And we've also seen after the Telegram incidents, many people calling into our center because they are scared and fearful that their videos and their images might be out there being shared and distributed by people unbeknownst to them. So we try to provide support, but if a person calls in with this vague fear and a vague anxiety without clear evidence of the fact that their images have been distributed, there's a limit to the kind of advocacy and counseling that we can do. We try to come up with more psychotherapy or other kind of counseling services for those types of victims. Recently, we've also seen more increasing cases of what we call body cam phishing images. So we've received a lot of calls from people when their distribution has been made through various messenger videos like Kakao and Telegram, WhatsApp. We try to work together with those developers, but it's difficult to remove all the images. This can lead to secondary or tertiary damage through online grooming and other instances, so we have to work really quickly on this. Next, I'd like to move on to sexual harassment or cyberbullying. The sexual harassment in cyberspace is a very big umbrella term, and this encapsulates many different kinds of harassment. This is not just relegated to various images. Of course, in many cases, it starts with images and it starts with videos. But other than these image-based sexual violence, there are other areas of sexual harassment. So, for example, maybe somebody would hack into another person's device to try to steal my phone. Or if I were to put my profile pic on Instagram, somebody would use that and Photoshop it with a graphic image and have that distributed elsewhere. And I'm going to elaborate on this a little bit further when I talk more about the Telegram case. The characteristics of especially minors who have been subjected to digital violence, we see that these minors, these young children are digital natives. They were really born with the knowledge of this, and they're very used to using this digital environment. And their culture is that they feel very much used and familiar using digital devices. Foundation in Korea issued a survey to about 600 middle schoolers or junior high students in 2017. Over 50%, nearly 60% of them said that you can have a friendship all online over the phone. And 21% said that I can have a romantic relationship with someone I meet online. And over 19% of them said that, yes, I've shared my pictures with somebody I've only met online. So this means that there's going to be higher instances of what we call online grooming because of all of these close personal relationships that form in cyberspace. Through one-on-one chatting, these chat forums and chat rooms, a perpetrator might advance a minor and establish a close personal relationship with them, get their images, and then distribute them. I mentioned a little bit about online sex exploitation, online sexual exploitation, together with online grooming. Rather than having this as one type of crime, they are different kinds of types of crimes that really overlap together and sometimes appear together. I have this separate slide on online sexual exploitation because I wanted to delve a little bit deeper into the different Telegram incidents that we've seen in the early part of this year in Korea. Minors, especially young children, teenagers, are very much preyed upon in these chat rooms. So their images are stolen from social media. And in many cases, some people have behaved like they are authorities, like they are the police, to get closer to minors and then get their images and then threaten and blackmail the minors, saying that they're going to distribute this online. And because of these blackmails and because of these threats, the minors feel like they have no choice but to submit to rape and other sexual abuse. The Telegram incidents were first known through the use of all of these different social media channels like Kakao Messenger and different messenger applications. So we tried to provide support in the form of having these images removed from these different messaging applications. And even within the Telegram application, we've seen different secret chat rooms later on made and opened for these perpetrators to go and hide when we take down one chat room. And so it's very difficult to try to access this kind of information. Because of these Telegram incidents, in April of this year, the government issued a government-wide response. And as I mentioned, they passed a supplementary extra budget, which is why we were able to hire a team of additional 50 more people into our center. So for this, instead of just providing post support to the victims after they call in their sexual abuse to us, we've tried to move with more resources preemptively to try to monitor all of these different chat rooms and different applications to see if there are any graphic images or non-consensual images that are already being distributed. In many cases, we see these composite photographs or Photoshop photographs where people would just download profile pics off Instagram or whatnot and Photoshop that together with graphic images and even put text on top of that. And recently, we've also had the inclusion of a new provision in our relevant laws, including the use of deep fakes. We've tried to really lobby the government to try to pass this. Hopefully, with this deep fake provision, this could give us a legal basis to take down more of these instances. But in many of the cases, some perpetrators who have been found to sort of just sexually humiliate the victim, this kind of case has not really been prosecuted to the fullest degree that we feel it is necessary. So that is one area that we find a little bit discouraging. So next, I'd like to move on to the deletion program that we have, where we work to remove the images and videos from online, from cyberspace. I don't have a lot of time, so I'm going to try to move quickly here. We provide this removal support based on the Act on the Prevention of Sex Violence and Victim Protection, Article 7.3. We ask online web supporters, these online applications or the domain hosts or the websites to help. We ask them to take down and remove these images. So it's very important that we have good international cooperation and collaboration with these domains and with these servers. We have come up with our own system to try to provide this removal support. We have a DNA values search system that we can do a sweeping search through this center, do a crawling search, and then ask the domain or the web server to remove the images. We also developed this system last year with the application called WebHard in Korea. So for all web hard drives, we can do a complete comprehensive search across all of the web hards, these hard drives online in Korea to try to search for all of these images. We also work closely with the police agency, obviously. So we have a regular investigative cooperation with the police agency and obviously with the victim's consent. We share this together, share the information together with the police agency to facilitate their investigation. Lastly, I want to talk about cooperation with these online platforms. This is very important for us. At our center, we have to work closely with Naver, Google, Twitter, Facebook, all of these different platforms and websites. We are working closely with them. We also have dedicated channels for each of these different platforms. So even in this COVID-19 era, we meet them through Zoom to try to ask them to continue to work with us in removing these different images. And also these online platforms have been very active in stepping up their efforts to working with us. At our Advocacy Center, we really try to look at all of this from the point of view of the victims, and we try to come up with a strategic, very comprehensive support for our victims. With that, I would like to conclude my presentation.
Thank you very much once again for our distinguished speakers for sharing their insightful and informative presentations. Now we move to the panel discussion session. First of all, let me introduce our discussant, Dr. Yoonho Jo, professor at Dongguk University, and Senior Superintendent Jong-sang Choi, Chief of Cyber Investigation Division, Korean National Police Agency, and Ms. Seonghe Seo, Representative Director of Korea's Cyber Sexual Violence Response Center. The panel discussion is conducted in a way where questions will be raised by designated discussant and answered one by one. As you know, we are a little bit behind the schedule, so please have each Q&A sessions within 10 minutes. Now we start with Dr. Jo. Dr. Jo, please proceed your discussion and questions.
Thank you. I'm Yoonho Jo in Dongguk University, Seoul, Korea. I'm glad that I have this wonderful opportunity to participate in the discussion the issue of the technology facilitated sexual crime. Today, Professor Bosler had introduced one new manifestation of a technology facilitated violence, which is the non-consensual production and distribution of private sexual images. What we can conceptualize as image-based sexual abuse. Thank you. It was truly informative. I strongly agree to the idea that the image-based sexual abuse is highly based on the gender, the violence against women and children, which has to be dealt with the feminist criminological perspective. Today, I do want to raise some questions, 3 questions about this issue in order to improve the current the legal status of Korean criminal justice and the crime prevention policies of South Korea regarding this matter. First, Professor, I'd like to know whether there are a specific kind of rapid sexual image removal scheme for helping women, the victims in United States. I understand that the nature of victimizations and preparation were found to differ by gender, with male more likely to perpetrate this image-based sexual crime, and female are more likely to be victimized by a partner or ex-partner. In fact, there have been numerous tragic incidents in South Korea. Listening that young female victims of image-based sexual abuse had committed suicide after they reported they victimized experience to police due to the quick spread of their sexual image on cyberspace. A second question is about sentencing and kind of penalty legal issues regarding this matter. I'm wondering how this concept of image-based sexual abuse law should be applied to individuals who simply watch and download the sexual image file instead of producing and distributing the images in United States. I wish if the Professor Bosler can delineate the differences of applying this related law to offenders who just simply download and keep these illegal files, particularly when the victims are minors. Third, My last question is related to my personal kind of experience as a practitioner. Perpetrators who engage in image-based sexual abuse have diverse motivations, such as revenge, personal revenge, building their social status, sexual gratifications, or kind of control, sense of control, or humiliation and monetary gain, and so on. This image I'd like to know what will be the most suitable correctional management strategy and investigative technique toward the criminal who committed this image-based sexual abuse. Previously, I was a probation and the parole officer, so I'm wondering what will be the professor's kind of the idea about modifying this problematic behavior. Sex offender registration and notification law is usually applied to traditional sex offenders such as rape in Korea. Moreover, policemen are not allowed to resort to engagement officially to arrest suspect of committing child grooming crime or image-based sexual abuse in South Korea. So I hope these three questions can be addressed by Professor Bossler. Thank you.
Thank you to Dr. Cho for her comments and questions. With my 5 minutes, I wanted to try to reiterate some of my key points and also try to answer and address some of her questions without speculating too much and going out of my own expertise. First, I do want to agree that when we view image-based sexual abuse, we do have to keep on viewing it as a cultural harm, as she pointed out. That's just not a crime against a specific victim, but that it occurs so frequently against women and children that we really do have to view it as the really large societal harm that it is. That over the last few years, with the Me Too movement in the U.S., there's been a lot of passage of laws to try to address some of this stuff. However, there is a concern that all of a sudden, because of racial injustice and other issues, that maybe some of these issues regarding crimes against women and children might all of a sudden get pushed to the back of the priority list. And so I'm hoping that what we see is that we've seen some of these laws being passed over the last few years. Just within the last 4 or 5 years, we went from 40 to 48 states, but now it's really time to do something about it, actually enforcing these laws. Regarding whether there are specific rapid sexual image removal schemes for helping victims in the American criminal justice system, I believe the answer is no. The FBI, our Federal Bureau of Investigation, does have a database consisting of all known child sexual exploitation materials, but this database is really used more for local and state law enforcement investigations when they're trying to see whether there are when they're trying to compare hashtags in suspects' computers with the known database, so they can actually see whether someone has known child sexual exploitation material, or whether the person possibly has new child sexual exploitation. And as Dr. Bull and Dr. Park was pointing out, there really is so much child sexual exploitation material out there that law enforcement, unfortunately, in the West, and I assume most countries, unfortunately have to focus on the creation of new material because there's so much just existing out there. But regarding a database out there for adults for sexual images out there, the answer I think is no. Unfortunately, the responsibility to try to remove non-consensual sexual images in the U.S. appears to fall mostly on the shoulders of the victim. I was really impressed to hear everything about that last presentation about everything that South Korea is doing, because I don't really kind of see that coordinated effort in the U.S. Usually victims, with the help of lawyers or nonprofits, have to contact each tech platform individually, very similar to what the last presentation was pointing out, and just keep on trying to find the images and keep on taking them down. And so it becomes a lot of obviously work for that individual, and can become very expensive if they have to also have get lawyers involved. I had talked about nonprofits such as the Cyber Civil Rights Initiative. They do have very helpful guides for victims where they provide the steps that victims can take for every single one of those platforms on how to get images removed. But that's still different than whether the U.S. has this, coordinated effort to try to help victims. That still really appears to be completely on the shoulders of the victims. And that's assuming they even know that they're being victimized. I want to kind of connect this to your third question, and then I'll come back to your second question. I think this actually ties in how we can improve victim advocacy and support for these crimes. You asked several questions about investigative techniques that law enforcement can take to address these. In the U.S., offenders convicted of these crimes can be placed on sex offender registry lists depending on the state. So that is a possibility within the U.S., but there really is not much, I think, great literature in the U.S. showing that sex offender registry lists are really strong deterrence preventions. And also in the U.S., most law enforcement agencies, either through state law enforcement agencies or task force, can conduct online covert investigations trying to catch the grooming of minors. But once again, those kind of are really focusing on crimes against minors and not really focusing on crimes against adult women. So personally, I think the real focus on addressing a lot of image-based sexual abuse by law enforcement really needs to happen at the local level. Patrol officers, first responders, detectives, police administrators really need to be better educated on this crime when they get called by victims, when they are responding to crimes. There need to be better resources to help them. I think we have to stop treating this as a personal problem, similar to how we treated domestic violence a couple of decades ago. Police officers need to know where to actually refer these victims to. This is an issue with cybercrime in general, where local law enforcement just does not know quite often what to do in the U.S. about cybercrime. They kind of tell them, I think they kind of just hope the problem goes away magically by itself, or they tell them to contact someone else. So with these cybersex crimes, it's kind of the worst of both worlds, where local law enforcement probably doesn't know how to really respond to cybercrime in general. And now they also really don't know how to help these victims of these cybersex crimes. So we really need better victim advocacy at the local level, that law enforcement can tell the victims, you really need to contact this agency, this organization. I can't personally help you, but you need to help them. And then hopefully that organization can help the victims start addressing some of these issues that especially was discussed in the third presentation. And hopefully a part of that could be one day a national database for image-based sexual abuse that maybe internet service providers and platforms are required to participate in. Kind of going back to your second question, you had asked about how image-based sexual abuse should be applied to those who watch and download compared to those who actually create and distribute the sexual image. I think when we're talking about the concept of image-based sexual abuse, the concept itself applies to both equally. Whether someone's distributing, downloading, or possessing these images, they're all part of the same culture that finds non-consensual pornography to be acceptable or simply to be a minor nuisance. So any activity, whether it's distributing or even possessing it, I think easily falls underneath the category of image-based sexual abuse. When you're talking about it from a legal perspective, though, it comes down to exactly what you're asking about, whether the victim is a minor or not. If the victim is a minor, in general, a lot of our state and federal laws regarding child sexual exploitation materials can apply. And they've been around for a while. They definitely they've had to be updated because of technology increases. So in general, that's why some states haven't done a lot if the victim is a minor, because they already believe that their current laws regarding child pornography should apply already. The bigger issues quite often is what happens is when the victim and offenders are both minors, because there's the issue wanting to protect the victim, but then also a society possibly of not wanting to possibly overreact to something that is going to have decades impact on the minor offender. Or the other issue is what happens when both are adults. And that's the issue I think that gets overlooked a lot. That as we've been pointing out, of course, our most, we have to focus the most on when the victims are minors. And we only have limited resources. But that quite often means that adult females are left out of getting help on these issues. If all our resources are going to simply to investigating and prosecuting the creation and dissemination of new child pornography, not much is left, I think, to helping adult women. So a lot of what my presentation talked about regarding the creation of new statutes at the state level in the U.S., I think were necessary to help victims who were adult women, because generally they're the ones that were being ignored in our system. I hope that my answers partially addressed some of your questions, and I would love if you want to send me emails. We can talk about it further.
Thank you.
Thank you, doctors, for the questions and answers. Next, Senior Superintendent Jong-sang Choi, the floor is yours. Please.
I am Director Choi Jong-sang of the Cybercrime and Investigation Division of the Korean National Police Agency. It is an honor for me to participate in this seminar as a panel. I have been working as the director since August of 2018. We supervise investigation of cybercrimes such as network intrusion, online fraud, and distribution of illegal contents, including child exploitative materials. I will carry on with my presentation in Korean because my English is not fluent enough to continue on. Okay. 아동 성착.
So I agree with the speaker's opinion that the sexual exploitation of minors is a global issue that cannot be contained in a single country or society. So I agree with Dr. Bo's opinion on that. So after the notorious Nth Room case was released, the Korean police realized that a comprehensive approach would be needed to tackle online sexual exploitation from the point of victims' protection and investigation. That is why, accordingly, a special investigation headquarters was established in the National Police Agency on the 25th of March for digital sex crimes, and special investigation units were installed on every level of the Korean police structure. So by the end of October, 191 online sexual offenders were apprehended, while 217 of them were detained. What is really noticeable is that the Special Investigation Headquarters does not limit victims of sexual exploitation only to children and juveniles. If sexual materials are created by coercion or blackmail, the Korean police would categorize them as exploitation materials and prioritize cases dealing with them, even if the victim is over age. So offenders are categorized into 4 different types according to seriousness of their crimes: producers or operators of abusive materials, distributors, possessors, reviewers, and participants. So these participants refer to accomplices who did not directly commit sex crimes. And this typology above was developed in the process of categorizing online sex offenders, whose victims are mostly composed of various illegal acts, such as doctor's room as well as nth room, and diverse charges are held to cover their varied violations. And starting 9th of May this year, buyers of child exploitation materials now face harsher sentences, while new statutes have been established regarding possessors and viewers of the materials. The typology and newly established statutes mentioned above are incorporated into investigation manuals used for law enforcement training. So, I have a question to Dr. Bo. So the Korean law enforcement tackles online sex exploitation crimes with an integrative approach, end-to-end approach, aiming to apprehend all offenders ranging from suppliers to demanders. It makes no difference whether a certain case began with possession or distribution. Do other law enforcement train investigators to approach cases according to typology, such as possessors or producers, and have segmented manuals according to typology? What are the benefits of segmented approaches? Second question is that the Korean penal law now restricts viewing of child exploitation materials according to the belief that it is the strictest instrument to prevent sexual exploitation of minors. So are viewers defined separately from buyers and possessors in other countries such as the United States? Do statutes regarding them exist in other legal systems? Lastly, does the notion of exploiting an adult exist in other countries? And if it does, how serious is it perceived as? I'd like to get your answers for that. Thank you very much.
Wonderful. Thank you so much for those questions. I'd like to start with the question you raised first about what different law enforcement approaches are used to think about these different types of offenders and training. And that's a really interesting question, and one that we've done a lot of work trying to unpack. I do work now looking at training for law enforcement in terms of technology facilitated crimes against children. And one of the first things we wanted to know is, what does the literature say about what training should look like? What does it entail in different jurisdictions, different countries? What's covered? And what we found was that there is very little publicly accessible information out there on what training for law enforcement entails. So those that are involved in a particular law enforcement system might be very familiar with their own training offerings, but people that are not inside the system typically are not provided access to that type of material. And that's likely due to the sensitive nature of this topic and the fact that perpetrators could potentially use what is learned about training to either avoid detection, to think about ways to circumvent prosecution, potentially to further their abuse. So there's a lot of reasons why there's some pressure to keep information about what's included in these types of trainings confidential. So I'll start with that there's not a lot to draw from to be able to speak to what's going on in different places in terms of how training of law enforcement is approached and whether typologies or thinking about different types of offenders is part of what's being considered. We were able to find some very limited resources that spoke to some of the topics that were covered, and offender typology wasn't something that was explicitly listed in any of the materials we identified. Instead, they were more geared toward unpacking what does technology facilitated crimes towards children entail, what are the competencies that are needed to investigate these crimes, what are some of the relevant software and hardware that law enforcement should be familiar with to work these crimes, and then also some legal issues and kind of recent court rulings that might pertain to these cases. So really not evidence directly that that's being covered. I think we could make an educated guess that typologies might be part of the discussion, at least broadly, in those kind of introductory, what are these types of crimes and who are these offenders discussions. But the extent to which typologies are linked to some of those aspects of decision-making is just not known, and quite frankly, probably doesn't exist, is my guess, at least not on a widespread scale. So there's definitely a tension there of we don't know enough to be able to say for certain what's going on in different places. Let's see, in terms of your second question, which is thinking about viewers versus buyers or possessors of these materials and what other countries are doing. I'm not super familiar with countries outside of the United States, so that's the one I can speak to most accurately, I think. So I'll stick with that. But I think this is another one where there's not a great answer. These types of crimes are constantly evolving, and statute often struggles to keep up with the different things that are happening in this field. And right now within the US, there's ongoing debate about whether an act like scrolling through a website that has exploitive content is the same as possession. But currently in statute, there's not a distinction between the two. They would, both be under the possession umbrella. There are some aspects of these crimes that are distinguished in statute. So for example, possession is distinct from receiving exploitive materials. But even with those distinctions, it still remains fuzzy because prosecutors have a good amount of discretion to be able to think about how they leverage these charges. And so, for example, there may be, they may be able to make the case that in order to possess exploitive material, you have to have received it somehow. And so both of those types of charges would apply. And so there really is a lot of latitude in that way. And so it's interesting that South Korea has already done some work differentiating those types of offenses and being able to separate those into different statutes, because I think there's a lot that could be learned about how that impacts both rates of offending and also prosecution of cases, if there are ways to kind of catch people earlier so that they don't progress to more serious offending later on. So I think that's really interesting and something that does not exist in the US to my knowledge. And then the third question about the notion of exploiting an adult. And it's funny that for that question to come up, it came up so perfectly with Dr. Bossler's presentation, because I think what he described is a really great example of what exploitation of an adult could look like. And there are, lots of countries that take that type of crime seriously. I know that countries like England, Scotland, Germany, and France all have laws around revenge pornography, making that a crime. And like Dr. Bossler mentioned, in the United States, 46 states have laws making that type of behavior illegal. And I was curious to see kind of how the states captured crimes that were focused, these types of crimes that were focused on just minors versus adults. And so I did a little digging, and it was interesting that some states really are specific to adults. And so they have these laws in place, but they're only applicable to those over 16 or 18, whatever the age of consent is. And they use the, more traditional child exploitation laws to cover any of these types of crimes that would relate to children. But others are more broad and could be applied regardless of the age of the victim. So there's some differentiation there. But I think that is a really useful example of what exploitation of an adult looks like, and something that is a topic of interest around the world. So thank you.
Okay, thanks for your discussion. And lastly, Director Seonghe sir, you have the floor.
네, 안녕하세요. 서승입니다.
Yes, hello, my name is Seonghe. I would like to thank all of the speakers for the very excellent presentations. Beginning in 2015, the feminist reboot movement has really tried to make their voices heard on cyber sex exploitation and sexual abuse. Our center, the Korea Cyber Sexual Violence Response Center, has been established in response to that. And in 2017, we've seen a lot of changes in Korea. After the establishment of the Women's Human Rights Institute of Korea, the government has announced three different measures, three master plans against cybersex violence. And we've also seen the establishment of the Advocacy Center for Online Sexual Abuse Victims, with the establishment of helping victims with the removal of the images from online. There are various regulations and laws that were implemented as well, such as the Act on the Prevention of Child Sexual Abuse, and the Communications Network Act was also amended. The new sentencing guidelines have also been strictly increased, which will be passed and go into effect this week on December 7th. And so we've seen a lot of these different changes, which to a large degree were very encouraging for us to see here in the community. However, what else can we do to try to eradicate this kind of violence altogether? So I think that right now we are at that turning point, a transition point for us to think about what we must do for the long term to fully eradicate this kind of violence from happening in the first place. And in my discussion paper, I wrote about what we have to do both from the legislative point of view and a policy point of view. So first of all, these cyber sexual violence that is not image-based should also be looked at as a crime. So there are a sexual violence that is being committed in cyberspace without the use of images or videos. And there needs to be a new implementation of punishment for online grooming. And we need to supplement the punishment for image-based sex violence for minors as well. We have to solve all of these different challenges. We shouldn't just keep that perspective where we're going to punish this because the images are graphic. That's not the focus. The Communications Act and the Communications Network Act should also be amended so that we can enforce more regulations against the different platforms and the websites to try to have them more active in participating in these different advocacy efforts to help victims. We have visited CCRI, as Dr. Bosler said, in the U.S., because there are many different websites that are hosted in the U.S. with servers in the U.S. that have all of these different images. So it is important for us to engage in international coordination to have a sort of a law on Inotech to make this all possible. In terms of policy, we need to have a comprehensive national support network to try to provide relief to victims. Right now, we do have a very good support network here in the metropolitan area around Seoul, but the victim advocacy network is not very expanded in the smaller towns, especially the rural towns and smaller cities across Korea. And so we need to expand that network. And also we need to move beyond just removing the images, but also try to do more in terms of a criminal punishment and extend investigation to look at these different websites and the platforms. There are these different nationwide support systems for victims, but many of them are also not accessible to victims, so we have to improve the accessibility for victims to them. Cyberspace is also a space in and of itself, so we have to find different creative solutions to try to intervene in this space and try to provide more relief in this space. These are some of the different comments that I wanted to raise. And what we can do in terms of responding to the challenges for image-based sexual violence going forward. And I wonder what Ms. Park thinks. What are the different challenges? What are the most important challenges that you see right now for us to do in terms of eradicating image-based sexual violence? Yes, thank you very much. We are the only public institute offering this kind of advocacy to victims of image-based sexual violence. And I would like to take this opportunity to thank seonghe because she's been very active in providing us with support when we were first founded. They have a longer presence and longer history than us. So I'd like to thank her and her team for providing us with a lot of advice and support. I know that just removing the images and videos are not a completely effective scheme. It's not a perfect scheme because, as I mentioned before, a lot of these will be distributed further and it's not completely fully enough to help and support the victims. They need other different kinds of multifaceted support. But we thought that removing these images is still very important, which is why that's what we decided that we should do, because this is something that we could do with a public focus. Because we're a public, government-sponsored organization, we thought that that would give us more reach an influence over platforms and tech companies. So that's why we thought that that would give us more influence to work with them to remove the images. And we also felt it was very necessary to provide victims with the support that they need. Removing the images is something that we can continue to do, but we are continuously working with online platforms, online IT tech companies, and we want to do further. We should move beyond just sanctioning or just removing the images after they've taken place, do something a little bit more preemptively, which is something that I mentioned in the presentation. But there's a very little limit to what we can do before the act has taken place. So I think it's very important for us to educate and train and raise the awareness of tech companies, of these platforms. So instead of, yes, coordinating with them and working together with them to take down the images is very important, but we thought that we should also engage with them with more discussions and training and education so that the tech companies can also see for themselves how damaging the distribution of these images is, so that they can also have a heightened level of awareness and really agree with us on the importance of this matter, so that they can even step up their game even more in helping us with the removal of these images and victim advocacy. So that's another thing that we are doing.
All of questions and responses are very intuitive and informative to us. Thank you so much for your participation out of your busy schedule. We have reached the end of the 7th KICIF International Forum. On behalf of the organizer, I would like to once again thank our speakers and all participants.